This portion of Living Local Carolina is sponsored by Lawyer Lisa. Joining us today is attorney Lisa Hostetler Brown to break down an important legal topic that could affect you. Thanks for being here.
Hi, I'm Lisa Hostetler Brown, and this is Legally Speaking with Lawyer Lisa. So you may have heard about wills, but I want to dig in a little bit about why you might need a will and what exactly it means. So a will is a document that you execute while you're alive that says where your assets are going to go after you pass away. Wills can be very simple or they can be really complex. You may have heard some stories about handwritten wills and them being found later on. We've all heard celebrity stories about this. Sometimes people can't find the original will when somebody passes away. This can actually be a really big problem. But let's talk about what you need and what you should be looking for. So in South Carolina, a will is a document that you execute with two witnesses and a notary. It's required to have this formality to it. So if you write your will on a napkin, it's just not going to do it for you. But that will is going to say, among other things, where your assets go when you pass away. It's also going to have the ability to direct who you would like to be what's called a personal representative. This document is where you can make changes to what the law says about where your stuff will go and who will be in charge when you die. So if you don't have a will, the state will actually give you a will through our code of laws. So if you don't know what it is or you don't have one, you do. The state has just made that decision for you. And of course, it's subject to change. As laws change, what happens with your stuff or who might receive it can change as well. So having a will is an important way to say, here's what I want when my assets might have to go through probate after I pass away. So what is probate? Well, probate is the court process from taking stuff from your estate and passing it through the court and saying who gets it at the end. Now, there's definitely some problems and difficulties that people encounter inside of probate court. And so there are alternatives to going through probate, like using beneficiary designations or joint accounts, having a transfer on death provision, or utilizing trusts. And we will talk a lot more about trusts in our future Legally Speaking. But for today, when we're talking about wills, it's important to note that you have to have these provisions and it has to be properly executed in order to change what the default is. Now let's say that you own a house and you have a will. That means that your house will go through that probate process, which roughly speaking takes about a year. It can finish up a little bit sooner. A lot of times it does take longer, and that's if there's no fighting. Now, why do people fight when things go through the probate process? Well, it's because your stuff is all in court already. And so it's just natural that if people in your family or close relatives are getting notices from a probate court, that they might say, well, I don't know what's going on, or maybe I do need to hire a lawyer to see what this is. And that's kind of how these things accidentally sometimes snowball into litigated court proceedings. Again, a lot of this can be avoided by utilizing trusts and other ways of transferring assets. A will is also a great way if you're a parent of a child who's either a minor or somebody you care for with special needs, that you can say who you would like to be their guardian in the event that you pass away. Now, if you and their other parent pass away, you can say what your wishes are as far as who that person should be that will take custody of your child. Now, it's not a done deal. The family court has to say this is okay as well, because what if that person's not the right person anymore? But it does give your wishes and it does enjoy some priority at that time. It's also really important to set up things if you have a complicated family situation. If you do have a blended family or you do have a special needs child, again, I probably would utilize a trust for those things, but at the very least, if you're going to have a will, you need to have provisions set up that include a trust inside of your will. Again, it's going to go through the probate court process, but at least you'll have stuff set up so that your children aren't inadvertently inheriting from you, which is what happens if you don't have a will and your children are your beneficiaries. Very important to consult with an attorney about your particular situation and develop a plan. Remember, it's not about the documents. It's about the plan that you're putting in place and then getting the documents to match with whatever your plan is. So while a will might be part of your plan, or another combination of a trust and some asset beneficiary designations might be your plan.
Our thanks to lawyer Lisa for sharing her valuable insight today. If you'd like more information or have questions on the topic, be sure to reach out at the website or the phone number on your screen. Portion of Living Local Carolina is sponsored by Lawyer Lisa.